Right there? Got it. Okay, good morning, everyone. My name's John Hurley. I'm going to be your judge this morning. You're at First Appearance Court. Let me advise you, you have the right to remain silent. You're not required or expected to make any comments today about what caused you to be arrested. Now, if you decide to make any comment today, everything's being recorded. Understand it will be used against you down the road, perhaps in a trial. Your attorney, public defender or private attorney, I can assure you would tell you the same thing I'm telling you. Don't discuss your case here in open court. Save it for your attorney in a private meeting. Now, if you do say something, this is recorded. The prosecutor can get it and play it for a judge or a jury one day down the road, and I can assure you, you'd probably come back and regret that you made the comment. Now, also, when you get called up, if you have a private attorney, let me know who that is. We'll contact your attorney and let them know that you're in court today. I just want to ask everyone in court today that do not state anyone's juvenile history on the record. If we have a juvenile history, we'll go sidebar. Any alleged victim of a sex crime, please do not say their name. Please use initials for that. Also, no names of juvenile victims on the record. And State, I'm going to ask you if anyone is a registered sex offender or sex predator, please let me know.
Yes,
all right? Thank you. All right, so let's call the first case, Mr. Jesus Mendez. Good morning, sir.
Good morning, Judge.
How you doing?
Good morning, Judge. Larry Davis. I'm here on behalf of the family and Mr. Mendez. Just so the court's aware, we'll concede as far as probable cause is concerned this morning. But Mr. Mendez has had absolutely no contact with the criminal justice system before. He lives with his mom in Pembroke Pines. He's worked steadily, although apparently where he worked suspended him because of this case. And we're asking, I know...
hold on one moment. Hold on. Do we have a mic from another jail over there that's on? Okay, that's that. Okay, go ahead, sir.
Thank you, Judge. I've talked to Mr. Griffiths as far as bond. He was going to ask for $10,000 per count. I would just ask the court to consider a lesser amount because this could be hard for the family. But they are going to bond him out one way or the other. And his mom's here, and he lives with his mom. And again,
let me have the state introduce yourself.
Good morning, Your Honor. Justin Griffiths, on behalf of the state. Mr. Davis was correct. The state's going to be asking for $10,000 per count. We're also asking for a level 2 GPS with a 1,000-foot restriction for any parks, playgrounds, schools, and places where children would congregate, as well as no use of computers, internet, or a smartphone.
Okay. How about the conditions? Do you have any issue about the conditions?
Well, the home where he lives, Judge, I don't think that's going to be that might be within 1,000 foot of a school or whatever, but he's been living there for 6 years. Matter of fact, he spent his whole life here in South Florida. He's not any kind of a risk as far as flight or not showing up for court.
I do note that in the police report, it does say that he has, in the past, worked for a local school, and he currently works for a local religious school. What about going back to the school to work?
Whether he's still employed there or not, that's up to Calvary Chapel, but obviously the 1,000-foot restriction that I'm asking for is going to preclude him from going back to the campus.
Okay. And I think he's already suspended, Judge. Just so the court's aware, he was an IT person. He wasn't having direct contact with the children, but I don't think that there's going to be an issue about him going back to work at the school at this point. They've already suspended him, and they were made aware of this.
Is level 2 a complete lockdown?
No, he's allowed to have a schedule.
Got it.
With pretrial.
Can I see his mom up here? Do you mind? Hi, ma'am. Raise your right hand for me. Do you swear or affirm to tell the truth? You can stay right there near the lawyer. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth? Okay, put your hand out. Tell me your name. Nice. I'm sorry we had to see each other under these circumstances. Ma'am, was your son born and raised here in South Florida?
Yes, sir.
Did he attend local schools?
Yes, sir.
Does he have family here?
Yes.
Do you ever know him to travel outside of the United States for any reason?
Only once for a missions trip with the church.
Okay. And how long ago was that?
Approximately maybe 5 years.
Does he have family outside of the United States? Close family? No? Okay. And will he be residing with you? Okay. All right.
So, Judge, also, he's a college graduate, master's level. I mean,
I understand. I'd also prefer his passport be surrendered within.
I will take care of that, Judge. If there is a passport, I will make sure I will surrender that. I'll take the responsibility.
Within 48 hours of his release.
I will give that to the clerk's
Okay?
office.
If you could get that, I guess 48 hours may not fall on
How about by
Saturday.
Monday?
Monday.
I'll have it in by Monday.
I got it. Okay. Now, Mom, does he own any land or property here in South Florida? You're going to be the person who's going to post his bond for him? Okay. State, you're seeking $10,000 per count. Am I correct? Total of $70,000. What do you do for work, ma'am?
For a bank, I'm an investigator.
Okay. And is there anyone else in your home besides your son who has an income that's coming in? No. And you own your own home?
No, I rent.
You rent? Okay. All right. Well, Mr. Davis, I'm going to consider he has no criminal record. Looks like he has excellent ties to the community. His passport gets turned in, so that dissipates a flight risk to a certain extent. The court's main concern at this point is any future criminal activity if he's released. I think a level 2 also dissipates that risk and some of the conditions we can put on him. So, ma'am, what I'm going to do today is I'm going to set his bond on each count at, just give me a moment, 1, 2, 3, 4, 5. I'm going to set each bond at $7,500, all right? And I think that's commensurate with the charges, the court's concern for the safety of the community. And there is always a flight risk on a serious crime like this, but I think we've been able to address that. What I'm going to do is order level 2, a level 2 ankle monitor, and I'm going to order that while he's out, he's not allowed to go on any school campus. That's any kind of school campus. He's not allowed to go into a park. He's not allowed to have contact with any child under the age of 18 unless it's a family member and unless it's in an open area, place like a mall or something like that, but no private one-on-one contact, all right? I'm going to also order that he's not allowed to use any device that has access to the internet.
Well, the sheriff's office has all its devices at this point, Judge.
But his mom probably has a computer at home or a cell phone, so I'm just going to order he's not allowed to have any access to any device that has access to the internet. I'm going to order, sir, you're not allowed to leave Broward County. You're not allowed to leave, you're not allowed to go onto airport property. You're not allowed to go into a port facility. You're not allowed to board an aircraft or an ocean-going vessel or a boat. Your passport will be turned in by Monday at the close of business to the clerk's office. Make sure your attorney or your mom knows how to get that.
I'll take care of that.
You're not allowed to obtain a replacement passport. I think, is there anything else? I'm going to order also no contact with anyone from Calvary Christian Academy while you're out on release. And unless they contact you first, you can't contact them, all right?
I'll do it, Judge.
Does that cover everything?
It does for the state.
Okay, so count 1 through 7, each bond's going to be $7,500, all right?
Okay.
Thank you.
Thank you for hearing
coming
us,
today.
Judge.
Yes, sir. There you go. Hey. Oh, sorry about that, Miss Patrice.
Let's get rid of the dust.
Sorry.
Thank you.
Okay. There we go. Any other attorneys here? No?
Your Honor, I do have law enforcement on a case.
Okay. You want to bring them up?
Sure. It's, defendant is,
When we call a case, if you're here on a case, just step right up here and we'll hear from you, okay? Which case is that, State?
Gennard Murphy. Page.
He's on page 22 of the docket, Judge. He's here at Maine.
Okay.
Mr. Murphy, come on up, sir. Judge, Mr. Murphy declined to serve as a public defender.
I understand, Mr. Murphy, it's best you don't make any comment about your arrest or what led up to it. You have the right to remain silent. I strongly suggest you utilize that right. Save any comment you have for your attorney in private meeting. Excuse me. Mr. Murphy, do you have a private attorney?
Yes, sir. I'm working on it, sir.
Okay, got it. Okay, Mr.
Your Honor, just first I want to advise the court before you make any determination. The state is not going to be seeking a probable cause determination for armed burglary. I spoke to law enforcement. The knife that is referenced in this matter is a butter knife, so it looks like it was more of a tool. So, and I know the court's familiar with the case law when it comes to those matters, so I'm going to be proceeding as a burglary with
So, okay. So you agree it's bondable?
Yes.
Got it. So the state has conceded that armed burglary is going to be not prosecuted at this stage. So, sir, you're charged with burglary of is it a structure or
a dwelling?
Dwelling. Burglary of a dwelling, possession of burglary tools, grand theft, resisting arrest without violence. You have 2 counts of that. Stand by 1 moment.
No, I'm at this point, if the court's finding probable cause, I'm not going to be eliciting any testimony.
Okay. The court does find probable cause. State, does this defendant have any criminal record?
Your Honor, the defendant is currently out on bond right now for armed burglary of a dwelling, structure, or conveyance, 2 counts of grand theft firearm and grand theft. He was arrested June 3rd and released from custody after posting $10,500 worth of bond on January 4th.
What's the case number?
Case number is 19313 CF10A. Now, just to advise the court for bond in this matter, Mr. Murphy is also out on another charge: possession of burglary tools, grand theft, possession of cannabis, obstruction, and theft. Now, I do want the court to be aware. He was arrested November 27th, released November 30th. The state has not yet made a filing decision on that case. Additionally, 2017, resisting without violence and loitering and prowling. 2010, dealing in stolen property, just over 28 months state prison. 2010, burglary of a dwelling with a violation of probation, 6 years in state prison.
That was juvenile. I was juvenile at the time.
He was tried as an adult.
Yeah, they're telling me you were juvenile at the time, but you were tried as an adult, charged as an adult. So.
Yes, sir.
All right. What do you do, sir? Do you have any money in the bank?
Yes, sir. Yes, sir. I got a job. Sir.
How much money do you think you have in the bank right now?
About $1,000.
All right. Do you own land or property here in South Florida?
No, man. I stay with my family.
Where are you from originally? Down here?
Yes, sir.
Okay. You go to high school here locally?
Yes, sir.
You have family here?
Yes, sir.
Okay.
I got 2 kids, sir.
Okay. And who's going to help bond you out of jail?
Part of my mom, my family.
Got it. Sir?
My father.
Sir, you're out right now on a serious felony case.
That's what he said. Somebody reported me, sir.
Right. Okay. So
somebody made an accusation on me, man.
Sir, you've already gone to prison for dealing in stolen property and burglary of a dwelling with a violation of probation, a prior loitering and prowling, and you have an open felony now. And allegedly on this case, you burglarized a dwelling and physically confronted someone. I'm going to go ahead and I take that back about the physical confrontation. I'm going to go ahead and set count 1 based on his criminal record, the facts of the case at $25,000. Count 2, possession of burglary tools, $5,000. Grand theft, 1,000. Resisting arrest, 100. And resisting an officer without violence, 100. The court's going to revoke the defendant's bond on 19313 CF10. That bond's revoked. The defendant will be held without bond until further order of the court. Thank you.
Your Honor, just in an abundance of caution, we ask for no victim contact, no return in this.
I don't know who the alleged victim is. Do you?
Then we just ask for no return to the property.
No return to the property on 12th Avenue, number 1 in Fort Lauderdale. Thank you.
Thank you, Judge.
Thank you. All right. May I see who else has a case here? Do you have a case? No? I don't know who. Ma'am, are you here on somebody? Yeah. Come on up here. Ma'am, who are you here to see?
Oriole Ward.
Male or woman?
Woman.
Woman, Ward?
Yeah.
Got it. Hold on one moment. May I see Miss Ward, please? Yes. Oh, sorry about that.
Approaching, Judge.
Okay. Good morning, Miss Ward. Ma'am, don't talk about your arrest, okay? Just save that for your attorney in private. Let me say somebody here on your behalf. Ma'am, raise your right hand. Do you swear or affirm, tell the truth, whole truth, nothing but the truth?
Yes.
Tell me your name.
Yasmin.
Yasmin? What's your last name?
Waldron.
And how do you know Miss Ward?
She's a friend.
Got it. Okay, Miss Ward, you've been charged with petty theft, first offense, possession of cannabis, license suspended, attaching a plate not assigned to the vehicle, and you have a couple traffic tickets after that. Also, you have 2 warrants. That's count 7 and 8. Oh, you have 9 for traffic violations, criminal traffic. Let me look here. Operating with no license is one of the warrants. Driving on a suspended license is one of the warrants. Unlawful tag or sticker is the other warrant. And you have new arrest for theft, cannabis, and license suspended. So, State, anything you want to add?
Just noting, I see 5 DWSs since, she's put out 5 DWSs since December, since 2017.
Defense, anything you want to say?
Judge, not at this time. She did give me the phone number of a friend to post her bond. I see her friend is here, so she appreciates her friend being here for support, and she's going to be relying on her friend to post her monetary bond, go through a bonds company. Judge.
Okay, I'm looking at her driving record right now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 prior failures to appear in court on her driving record. Plus, she has she's currently a habitual traffic offender. So, ma'am, you have a history of not showing up in court. So, I'm going to set your petty theft on count 1 at I'm going to set that at $2,500. Cannabis, I'm going to release your ROR on that. License suspended, $750, and then count 7 and 8 are going to be 100 per count. Thank you. There you go.
Judge, now that the court has actually raised a bond now, there are...
Did I raise a bond? I don't know that I raised a bond.
Well, I mean, you impose a bond.
Right, I imposed a bond, correct.
Correct. Judge, we were under the assumption that the standard bond the court would not disturb that. My understanding, she is working. She works at Taco Bell.
Right.
I don't know if Ms. Ward thinks that her friend's going to be able to come up with the new bond amount. So, Judge, I'd ask
Is there
you
a new
to
bond amount? I don't understand.
Well, no.
He's talking about the bond that you set on the theft.
Yeah.
$2,500.
You know, right, a convenience bond is one thing, but once the court reviews the history of not showing up in court on her driving record, the facts of the case and count 7 and 8 are charges for not showing up in court. So, I mean, the court gave her a bond that's appropriate for her current situation. So she can bond out. Thank you. All right, may I see Rachel Fernandez? Oh, do we have anyone else? Thank you, ma'am. Anyone else? Are you here on a case?
It's our victim advocate, Judge.
Oh, sorry. There you go. Okay.
Ms. Fernandez is here at Maine, Judge, and she is approaching.
Hi, Ms. Fernandez. Hi, ma'am. You're charged with aggravated battery with the deadly weapon. The court finds probable cause. Court does note that You allegedly poured salad dressing on someone, shook her, and threw her to the ground, and allegedly poured bleach all over her. So there is probable cause. State, do you have any priors on this, Ms. Fernandez?
I'm not showing anything, Judge.
Okay. Defense, anything you want to say about bond?
Yes, Judge, as the state confirmed, this is her first contact with the criminal justice system. She's 18 years old, and she did become a registered voter. She's been residing in South Florida now for about 14 years. She is a senior in high school, and right now she's also looking for employment. My
Okay.
understanding is, I believe the alleged victim, I believe maybe her mother.
Got it.
Judge, she does have a father who resides in Dade County that works in construction, that she's going to be reaching out to post her monetary bond, but from what she informed me, his financial resources are limited. I'm going to be asking you to take that into account in determining a reasonable bond for Ms. Fernandez.
I will. Do we have a victim's advocate in the courtroom? Ma'am, what's your name? Nice to see you, Ms. Garcia. Did you have contact with the alleged victim in this case, ma'am?
I did have contact with her this morning.
Okay.
I told her she could come to court and she said she could work.
Did she convey to you any concerns about her safety or anything like that? No? Any other information she gave you that the court could use in setting a release here? Okay, thank you, ma'am. I'm going to take into consideration the age of the alleged victim and her being a senior in high school and having no prior contact with the, do we have, does the GPS work in Dade County also? Okay, so I'm gonna give her a GPS level 2. I'm gonna release her on her own recognizance today. Ma'am, while you're out, I'm gonna order you're not allowed to possess any guns, any weapons, any firearms, any ammunition. I'm also gonna order, ma'am, you have no direct or indirect contact with, excuse me, Miss Baroa Yocasta. I assume that's your mother. And is your home address on 141st Avenue, ma'am?
Yes.
Okay, I don't want you to go back there. If you stay with your father, that's fine. But during the, while this case is going on, don't go back to that address. If you need your clothing or anything like that, have another family member contact your mother, pick up your clothing, but don't go back to that address. And don't have contact with your mother directly or indirectly. You understand?
Yes, sir.
Okay, thank you. Oh, she's allowed to go to school and have an open schedule, all right? Thank you. Okay, may I see, I'm forgetting how to do this stuff. Sorry, ma'am. It's coming back to me slowly. There you go. Did I? There you go. What about Bernandy Joseph?
Northfire.
I believe that's a medical reset, Judge.
Is it? Okay, so I'm going to write on here med reset. And we'll reset it for tomorrow morning. There you go. How about Fernando Rustan?
He's here at Main, Judge, approaching.
Hi, Mr. Rustan. You're wanted for out-of-state Illinois and for a fraud and burglary charge. You're going to see the extradition judge in the next couple of days. All right, sir? Good luck. I think extradition's this morning, all right? Okay, what about Danilee Martinez?
Ms. Martinez, come on up, please. She's here present at Main, Judge.
Hi, Ms. Martinez. Ma'am, you have warrants for failing to show up in court for driving without a license, failing to register your vehicle 2 times, operating with no license. So I'm going to let you bond out today. $250 on 1, $50 on 2, $100 on 3, and $250 on count 4. Good luck, ma'am.
Good luck, man. I'll call your mother-in-law after court.
What about Tahina Herard?
Bonded, Judge.
Bonded? Okay. Got it. There you go. How about Terry Silverman?
Medical reset.
Med? Got it. Med reset till tomorrow morning. How about Megan Ludlow?
She's approaching, Judge. She's here at Main.
Hi, good morning, Miss Ludlow.
Good morning.
Ma'am, you've been charged with trespassing. The court finds probable cause. State, do we have a criminal record on this Megan Ludlow?
She was arrested December 17th. I'm sorry, December 2017 on a VOP on a battery. Yeah, it was a felony that was pled out to misdemeanor battery resisting without violence.
Let me ask you, defense, is this something she wants to just plead out right now?
She does. She wants to resolve it.
Ma'am, Ms. Ludlow, raise your right hand. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do.
Okay, put your hand out. Tell me your full name.
Megan Marie Ludlow.
Okay, put your hand out, ma'am. Ma'am, do you understand you've been charged with trespassing at a place called the Backside Stables in Hallandale?
Yes, sir.
All right.
Yes, Your Honor.
All right, ma'am. Do you understand if you want to plead no contest, I'll just give you time served the night you're in jail, and that'll be the end of it. You'll get assessed a fine, which is a court cost, and they'll send you that in the mail, all right? Do you understand?
Yes, Your Honor.
All right, ma'am. Do you understand you don't have to plead no contest? If you want to have a trial, we could probably release you. You come back on another date and have a court hearing. Do you understand that?
Yes, Your Honor.
But your case is going to be over with today. You're not going to have a trial. It's wrapped up, done, over with right now. Are you clear about that?
Yes, Your Honor.
And I'm going to order, if you plead no contest, not to return to Backside Stables. Is that clear?
Yes, Your Honor.
How do you plead to one count of trespassing, ma'am?
No contest.
I'm going to withhold adjudication, assess the minimal court cost. You can send her that bill, and then that's it, ma'am. You're done. Thank you.
Just to avoid any confusion.
Hold on, ma'am.
Just to avoid any confusion from Ms. Ludlow, because I know you ordered no return of those stables. For all I know, the trespass warning is for all at Gulfstream, so I don't want her.
Oh, is it Gulfstream?
Yeah, this happened at Gulfstream.
Ma'am, let's put it this way. You probably shouldn't go back to Gulfstream, all right? I don't,
You know what's sad?
Backside Stables, is that a restaurant? Is that what that is? Or is that actually where horses are? Ma'am, you know better than I. What is Backside Stables? What is it?
It's where we ride the race horses.
So
I was a professional jockey there for 25 years, so.
Well, apparently, ma'am, they don't want you back there.
I understand.
If you want to go to Gulfstream to the other end of it or whatever, fine. Just don't go back to those stables, all right?
All right, thank you, Your Honor.
Yes, ma'am. All right, Teresa Jones.
Medical reset.
Okay, set for tomorrow morning.
Your Honor?
Yes.
One thing I would ask at this point, just so I can move my paperwork along, she's been reset several times, so the court can make a PC determination.
Okay, and then
I have no
just
problem
send
with
it to the division?
No, I don't have a problem with her coming back for bond purposes, but just so, you know.
Okay, I do find probable cause for count 1 trespassing, disorderly conduct, and she has a warrant on count 3, so there's PC for that, all right?
Thank you.
Oh, is there? Okay, find probable cause for that also, all right? There you go. Tomorrow, yeah, tomorrow. Thank you. How about Melanie Mendez?
Ms. Mendez is here at main judge approaching.
Hey, Miss Mendez, you've been charged with intimidating, writing, sending threats to kill or injure. And the court finds probable cause. Ma'am, don't make any comments right now about what did or did not occur. Just save that for your attorney in a private meeting, all right? Go ahead. State.
I don't see anything local. I don't know if pretrial has any notes on Ms. Mendez.
Okay. No criminal record. Miss Mendez, 25 years old. She has an address in Dade County. Defense, do you want to make any comment about this?
Yes, Judge, she's 25 years old, been living almost half her life here in South Florida. She is employed. She works at the Grand Beach Hotel as a server, where she's been employed there for 4 months, and she makes about $535 plus tip. She lives in Miami by herself. The rent is about $1,200. Now, she does have family that resides in our community, specifically her mother, Maria, who cleans houses for a living. That's who she's going to be reaching out to help post her monetary bond. So, Judge, I'd ask you to take that into consideration in determining reasonable release conditions for Ms. Mendez.
Okay, Miss Mendez, who's going to help bond you out of jail?
My mom is in Tampa, or myself.
Okay, all right. Do you have other family down here?
I have a friend that can bail me out, and yes, I do.
Did you grow up in Dade County, ma'am?
Yes, yes,
Okay.
Your Honor.
All right, ma'am.
Your Honor, if I could have one moment, I just need to check,
Go ahead, ma'am.
status on a case.
It appears that she was arrested indeed for a battery, and that was when they saw this out of county warrant that we have her here on. The battery does appear to still be open.
The battery's closed?
No, it appears to.
She's got an open battery in Dade County right now?
5 days ago is when I see the battery.
Got it. Ma'am, how much money do you think you have in the bank right now?
Not too much because I just got paid $700.
Do you own any land or property here in South Florida?
I don't know. I just have a car. It's worth nothing.
How long have you lived in Dade County, ma'am?
Around more than 10 years.
Okay,
12 years.
Ma'am, the court is very concerned about the facts of the case. Allegedly, you sent threats through text messages to murder someone's child, two of their children, and you claim you had guns to carry it out with. There is an allegation of some drug usage here. Ma'am, I'm going to set your bond based on the court's concern for the safety of the alleged victim. Your alleged statement that you possess guns, and along with it, I'm going to set your bond at $10,000 today. I'm going to order a pretrial release with a GPS monitor, level 2. She's allowed to have a schedule where she can work and things like that, but I'm going to order no contact, directly or indirectly, with the alleged victim. You must, and the name of the alleged victim?
One moment, Judge.
I didn't.
Yeah, I have it here. It's Emily Cannon, Your Honor, and I just asked that also include any of her family.
Emily Cannon. No contact directly or indirectly with Emily Cannon. You are not allowed to contact her, her children, anyone in her family. You're not allowed to possess any guns, any weapons, any firearms, or any ammunition. If you possess any guns, you need to get out. When you get out of jail, contact the local police. Tell them a judge told you you're not allowed to possess them. They'll come to your house and they will collect them and they'll hold them. So you're not allowed, hold on. You're not allowed to send any text messages or make any contact with Emily Cannon on social media. You're not allowed to have third-party contact. And you must stay 500 feet from her where she lives, goes to school. And that also goes for her children or child. No contact directly or indirectly. You understand that?
Yes, Your Honor.
Good. You have a question?
I just wanted to say.
Wait, no.
Sorry,
First
question.
Hold on one second.
Oh, you can ask a question, but don't tell me a statement.
Nothing added this time.
Okay, thank you. There you go. Yes, GPS level 2. Thank you. May I see Annette Cave?
North Broward.
Judge, on Annette Cave, count 2 was booked as a DOP.
Right.
Could you cross that out and put misdemeanor? It's a misdemeanor.
Yes, I will. Got it. She's where, at North Broward? Got it.
Right here.
Hi.
Can you see?
Hello, Miss Cave. Ma'am, you've been charged with possessing a controlled substance on count 1, codeine. Count 2 is a violation of probation on a misdemeanor for trespassing.
I have a
Don't discuss the facts of your case.
Did my brother bring it in?
Oh, no, ma'am. I don't know about that, but let's see here. Your violation on count 2.
Judge Levy?
Yeah, so count 1.
She's supposed.
Go ahead, ma'am.
Tell me when I can talk, okay?
Ma'am, your bond on count 1's $1,000. Your bond on count 2 is $5,000 on your violation of probation. What do you want to say, ma'am?
Okay, Judge DeLivy has a motion to disqualify herself. So who's ruling on that?
That would be her. all right?
Okay, but she can't, I don't think she can rule on any motions till she rules on the motion about her disqualification. This is I don't know if you're aware of the whole case or not.
Let's be clear about this. I surely can't rule on whether she's disqualified or not. That's going to have to be something you go over there and straighten out. Good luck.
No.
The defendant is currently being supervised by pretrial services.
Right.
Case 18-174 CF10A. One count of trespass structure with dangerous weapon. One count of criminal mischief. Okay. Based on this court's finding of probable cause, we're going to act that her pretrial status be revoked at this time.
Yes, ma'am. I'm going to do that. Thank you, ma'am. I'm going to revoke your pretrial status. You're going to be held without bond on case number 18-000-174 CF10, trespassing structure with dangerous weapon and criminal mischief. They're both going to be no bond holds. Thank you, ma'am. There you go. Okay, let's see here. Yorlam Rivas. Lenny.
Is she your president?
Thank you.
Come on up, ma'am. Does she inform me she has private counsel?
Okay.
Brian Valacera.
Okay. Hello, ma'am.
I tried to find him, Judge, but I couldn't find him in the Florida bar.
Ma'am, do you happen to know your attorney's telephone number?
No.
Do you know where he's located, where his office is?
Somewhere in West Palm, I'm ready to know yet.
Okay, do you know how to spell his last name?
That's how I remember right now.
Okay, well, the public defender over here has told me that he's attempted to reach out. Hold on.
Is it Brian Balladera?
Is it Brian Balladera? That's it. Do you have a... Ma'am, are you okay over there?
Yeah, I'm just having an issue throat.
Maybe somebody could get her some water. Go ahead. Stay. What's the number? Could I ask main jail to keep the noise down? Thank you. Go ahead. Give me cell. 561. Okay. 80 what?
16.
Balladera?
Balagera.
Balagera?
Yes.
Brian Balagera.
Hi, Mr. Balagera. This is Judge Hurley in Broward. How are you?
Hey, how you doing?
Good. I'm in first appearance court in Broward right now. We're on the record. We've got a person here, Yorlani Rivas, who says that she's your client. You know Miss Rivas?
I did represent her recently, and her case was dismissed.
Okay. Was that in Broward or West Palm?
Broward.
Well, right now she's been charged with false identification given to the police, possession of cocaine, drug paraphernalia, and she has 2 warrants on misdemeanors that are here. Let's see. They are compulsory school attendance violation and operating without a valid license. Those are capious warrants for her. So she's currently in the Broward County Jail. She's going to have a bond of about $2,200 total, all right?
Okay.
So I'm letting you know, all right, sir?
Okay.
Okay, thank you. Have a nice day.
All right. Thank you, Judge. All right.
Okay, ma'am. That's it. Your bonds have been set, and we let your attorney know that you're in jail. Good luck.
All right, thank you.
Yes, ma'am. How about Angela Amonte?
She is approaching, Judge. She's your main.
Mr. McBride?
Hi, Miss Amonte. You've been charged with possessing cocaine. Court finds probable cause state. Do we have a criminal record on Miss Amonte?
Yes, Judge. 2018, possession of heroin, 60 days county jail. theft 2017, felony theft 2016, felony theft 2016, possession of cocaine 2011, cocaine 09, felony prostitution 07, felony prostitution 07, possession of cocaine 07, heroin 06. It goes on from there, Judge.
Got it, ma'am.
Judge, if I could be heard.
Go ahead.
Ms. Monty, basically, she resides with her boyfriend. He works in landscape. And I asked her, is the boyfriend in a position to post her monetary bond? From what she informed me, no. Right now, she actually cleans houses for a living. She gets paid about $20 per house that she cleans. And she said last week she had no clients, so last week she made $0. She has no money in the bank from what she informed me. She's asking the court to consider releasing her on pretrial release on this nonviolent offense.
Okay. Ma'am, based on your long felony history that has just been stated by the state of Florida, 2 heroin cases, 1 last year, petty theft, felony petty theft 2 times, 2 prior cocaine, a prostitution, felony prostitution, your bond's $1,000. Good luck, ma'am. Thank you. Tedria Sanders.
Sanders is here in Maine. Come on up, ma'am.
Hi. Good morning. Burglary of a conveyance, a vehicle. Court finds probable cause stated of their priors on Sanders.
As far as Broward, I just see an old trespass from 05.
Okay. Allegedly broke into a vehicle in front of the alleged victim and took a book bag. I do note that Ms. Sanders has been known as Jane Doe and Kim Small in the past. No.
Your Honor, I'm showing, yeah, I mean, she has priors, but the most recent in Florida was 2005.
Judge, that's what Ms. Saunders advised me. Her most recent contact with criminal justice is 2005. She's 48 years old. She's unemployed. She gets disability. She gets approximately $750 per month. Unfortunately, what she advised me, she lives with her husband, and right now she doesn't have her phone with her, and her husband doesn't know where she's at. So, Judge, she's asking the court to consider releasing her on pretrial release.
Ma'am, do you still live on McClellan Street?
Yes.
And what's the street address there, ma'am?
What's your address?
2314 McCullough Street, apartment 3.
How long have you lived there?
Going on 2 years.
Okay, ma'am, I'm going to release you on your own recognizance, but you have to report to pretrial release. And then you need to report there. Can she get there today?
Yes, sir.
It's right across the street from where you are right now, ma'am. As soon as you get out, you need to head on over. All right?
Yes.
You are not allowed to have any contact with Espinal Celestine or Samantha Maylin and any of their vehicles or any direct or indirect contact.
That's just one full name.
Oh, sorry about that. It's one full name. I guess it's, I'm not sure.
Celestine.
It's what?
Samantha Celestine.
Oh, it's Samantha Celestine. You can't go near her vehicle. Stay away from her. No contact, all right? Thank you, ma'am.
Yes.
All right, man. I see Sarah Richard. Mr. Jones, do you have a case?
Yes. Next case.
Okay. Sarah Richard, where are you?
She's here at Main, Judge, approaching.
Ms. Richard, failure to redeliver a leased vehicle, specifically a U-Haul van. Count 2, operating with no driver's license. Court finds probable cause. State, do we have a criminal record on Miss Sarah Richard? Anything the defense want to say?
Judge, at this time, no.
Okay.
Getting.
See a Winter Haven address, Winter Haven, Florida on her driving record.
She's got old priors out of Pennsylvania and a traffic prior out of South Carolina.
Right.
Showing last year. She may have an open DUI out of Brevard County. Yeah, it's still ongoing, her DUI.
Got it. Okay, ma'am, I'm going to go ahead and set your bond on count 1 at $1,000, RORE on count 2. You have an open DUI out of Brevard County right now, and also the court notes you have an address in Winter Haven, Florida, so the court notes the lack of ties to the community. Good luck, ma'am. You can bond out.
Thank you.
I'll call your friend right after.
Okay, thank you.
Sorry about that. What do you need? Oh, there you go. Boy, we're just about a well-oiled machine again. You know that? There you go. Okay, what do you have, Mr. Jones?
Barbara.
Oh,
Perrier.
hold on one moment. I have to go set. What do you have?
Barbara Perrier.
May I see Miss Perrier, Barbara Perrier, please?
She's approaching, Judge. She's here, ma'am.
Hi, Miss Perrier. Ma'am, you've been charged with some serious charges. I suggest you do not talk about your charges, your case today. Please remain silent and just save all your questions or comments for your attorney in a private meeting. Ma'am, you're charged with count 1, 2, and 3, aggravated battery with the deadly weapon, 4, criminal mischief, 5, throwing a missile into a dwelling, vehicle, building. Court finds probable cause. You have a bail bondsman here. We'll get to him in just a moment. Stay there. Priors on Miss Perrier.
I'm showing no criminal history, Judge.
No criminal history. Okay. Let me ask from the bail bondsman, sir, are you retained by the family to help her out?
Yes, on behalf of her sister, Shinovia.
Okay.
They have limited funds, so I spoke with the state attorney and looking to see at least 1,000 on each count.
1,000 on each count.
Well,
Let me ask.
3 counts.
Got it. Defense, what do you have to say?
Judge, as you can, as the state confirmed, this is her first contact with the criminal justice system. She's 18 years old, been residing in South Florida her whole entire life. She has family that live in her community. You heard from the sister. She also lives with, I believe, her child's grandmother. Right now, she's going to be depending on them to help post a monetary bond. So we'd be asking, as far as what was requested, $1,000 bond on each count, Judge.
I'm going to go ahead and do that, but I'm going to note that it allegedly threw a brick through a window, and the glass and the brick hit somebody on the inside of the house. They were only injured in a minor manner, but still underlying matter is very serious. The court will set your bond on count 1, 2, and 3 at $1,000 per count. And then I'm going to go ahead and count 4, the criminal mischief. I'm going to go ahead and release her ROR on that. And then the missile into the building, I'm going to set that at $1,000 also. Total bond's going to be $4,000. She can bond out, but I'm going to order no contact directly or indirectly with Mangina Raymond and Malaya Benami. No contact with them directly or indirectly, including Nasser Alexander and Brandy McClinton. You're not allowed to possess any guns, any weapons, any firearms while you're out. You must stay 500 feet away from where they live, work, go to school, anywhere in between. Thank you.
Right,
thank you, Mr.
Honor.
Jones.
All right, that's it.
Take care. How about Olivia Patterson?
Ms. Patterson, come on up.
Ms. Patterson, hey, good morning, ma'am.
Good morning.
You've been charged. Good morning. You've been charged with possessing cocaine, driving on a suspended license, habitual, operating with traffic ticket, and then you've got a violation of probation on a misdemeanor, which is holding you no bond. Let me see what that's about. That's a DUI, ma'am. Count 1, your bond's $1,000. Count 2, $750. You're going to be held no bond on count 4. You'll see your judge on the 18th. All right, ma'am? Thank you. There we go. How about Cynthia Rivers?
Medical reset.
Okay.
And, Your Honor, again,
I'll find PC on each and every count. I do note count 5 is not a county hold, and then I'm going to med reset it for tomorrow, all right? Okay, what about Richard Magali?
He's here, President Judge, approaching this morning.
Hey, Mr. Magali, how you doing?
How you doing, Judge?
Good, I'm doing well, thank you. Let's see here. Mr. Magali, you're here on a municipal ordinance violation, unlawful panhandling. Does he have any criminal record, State?
I'll check. He does, Your Honor, but the most recent Broward prior was a delivery of cocaine from '06.
Right. Okay, sir. So would you want to resolve your case today?
Yes, I do, Judge.
Plead no contest. You'll be out of jail today. Is that how you want to handle your case?
Yes, sir.
Raise your right hand. Do you swear or affirm tell the truth, whole truth, and nothing but the truth?
I do, sir.
Put your hand out. Tell me your name.
Richard Magali.
Mr. Magali, do you understand if you plead no contest, your case is going to be over with today? I'm going to assess minimal court costs. They'll send you a bill in the mail. Do you understand that?
Yes, I do, sir.
Do you understand that you don't have to plead no contest? You could say, Judge, I want to have my day in court. I want to have a trial. I'd be happy to probably release you on a $50 bond and let you come back and have a trial. Do you understand that?
Yes, I do,
But
sir.
if you plead no contest, your case is over with today. There's not going to be a trial. You're not going to have your day in court. Wrapped up, over with right now. Is that clear?
Yes, sir.
How do you plead to one count of panhandling?
No contest.
I'm going to accept that. I'm going to withhold adjudication, assess the minimum court cost. And be careful, all right, sir? I used to have this position as first appearance for almost 8 years. In that time, I'm going to say 12, 15 people panhandling in traffic were run over and killed. People that I knew would come in front of me, and they'd walk in traffic and get run over. So I'm just telling you that you may want to take a different route instead of standing in traffic, all right?
Can I say something, Judge?
Sure, go ahead.
The place that I was allegedly caught panhandling, I bought a Slurpee and I was having a cigarette. An undercover Hollywood police officer approached me and told me to get against the wall when he wrote me the citation.
Okay, well, it wasn't in traffic then, sorry. All right?
No, I'm saying, well, I wasn't panhandling.
Well, you just pled no contest, so, you know.
Okay, I know.
All right? Okay, good luck. Emmett, money.
Thank you.
We have money.
Mr. North Broward, I believe, Judge.
Who is, North Broward?
Yes.
Sorry about that, Miss Patrice. All right, good morning, money.
Morning, sir.
Sir, you're here on a misdemeanor warrant. Your bond was posted, sir. You're going to be out of jail shortly, all right?
Thank you.
Good luck. Okay, Michael Cade. Excuse me?
North Broward, I believe.
North Broward?
How are you?
Hey, how you doing, Mr. Cade?
I'm doing good, sir. Yourself?
I'm doing well. Mr. Cade, you've been charged with trespassing, Marathon gas station, sleeping by the entrance of the gas station, and, you know, they tell you they keep going back there and telling you not to go around there, and they say you just keep going back and back, and,
So this is a different place.
Excuse me?
Okay. This is a different place, but yes, sir.
Okay. State, do you have any priors on this gentleman?
Yeah, Your Honor, he's got he had 12 arrests in 2018. His most recent was a trespass arrest on the 27th at a different location. Looks like he got a 10-day sentence, was released January 5th.
Has he ever gone to Judge Lerner around that you can see?
I could check.
I know Mr. Cade did indicate to me that he would like to resolve this matter.
I understand, but there's an indication within the PC that there could be a mental health issue.
I understand what you're saying, Judge.
Let me check something.
Right, that's the type of shit I throw over. What the fuck is he? Why would I just because I'm sleeping have mental issues?
Sure, today I'm gonna go ahead and leave your bond at $100. I'm gonna send you over to Judge Lerner Wren. Okay?
Right.
Just to let Mr. Reedy know.
Right.
If the court is inclined to appoint a public defender, if you guys want to look into it, it looks like at some point years ago he was in Veterans Court with Judge Merrigan.
Sir, were you in the military at one point?
Yeah, you can see me in the Veterans Court.
What war were you in?
Iraq and Afghanistan. You can see me in the Veterans Court.
Okay.
That'd be nice.
I think
Let me put it this way: he had, from what I can see in Odyssey, he had enough appearances before Judge Merrigan that it wasn't a situation where like he was mistakenly sent there and they figured.
Right. Let's send it over to Veterans Court, all right?
Yeah.
Nah, I think that Judge Merrigan can kind of direct it the way it should go after that, all right?
Yeah.
After all, I went to high school with Judge Merrigan, all right?
Awesome, that's great. These guys are great.
Excuse me?
Thank you very much for
What were you in? Were you in the Army, the Marine Corps?
Army and Marines.
You were in the Army and the Marines?
Yes, sir.
Really? Well, that's pretty good. All right, well, good luck, all right?
Thank you, sir.
Excuse me? We all went to high school with Judge Merrigan. Yes, that is correct. His sister was in my class. He was a year behind me. Yep, I've known Judge Merrigan since he was the offensive tackle on my high school football team. I could always, well, yeah, he's a real nice guy. William McDonough. Mr. McDonough, are you there?
McDonough's here at Maine, Judge.
Good morning, Judge. Hi, good morning, Mr. McDonough. You've been charged with possession of alcohol on the beach. State, I find probable cause. State, do you have any priors on him?
This is on Ranco?
McDonough.
I'm sorry. McDonough. One moment, Judge.
Boz.
What's on the I'm sorry. Sign on the yellow one.
Yes, Judge.
No,
He was arrested last December, last November, July of last year, January last year.
What kind of things?
It appears they're all
Trespassing, alcohol.
Yeah, low level.
You want to work it out today, McDonough?
Yes, sir.
Raise your right hand. Do you swear or affirm tell the truth, whole truth, and nothing but the truth?
I do, yes.
Put your hand out. Tell me your full name.
William Wilson McDonough.
Sir, do you understand that if you plead no contest today, your case is over with? You're not going to have a trial. You're not going to have your day in court. Wrapped up, over with right now. You understand that?
I do.
All they'll do is they're going to send you a bill in the mail, all right?
Got it.
And you don't have to plead no contest. You tell me you want your day in court, and we could let you bond out. Do you understand that?
Understood.
Okay, how do you plead to one count of open container of alcohol?
I plead no contest.
I'm going to accept that. I'm going to withhold adjudication, assess the minimum court cost. Wish you the best, Mr. McDonough. All right?
Thank you very much. Have a good day.
Take care. Let me see our former public defender. Come on up. So for several years, this gentleman was our public defender in this courtroom, and now he's gone out and for bigger and better things. And I haven't seen him in probably a couple of years. So there you go. It's good seeing you again. All right. So you want to just go take Mr. Reedy's spot right over here, sir?
Be careful, Brian will run out of here.
There you go.
Yeah, I'll be gone in a heartbeat.
There you go. Good seeing you. Okay, may I see James Ranko?
Mr. Ranko is here at Maine. Come on up, sir.
Good morning, sir. You've been charged with driving on a suspended license, a warrant for your arrest, and I'm going to just look at something here, Mr. Ranko. I do note from Mr. Ranko's driving record that he's been convicted of DUI in the past. 2 times, 2 prior DUIs, and He's got a prior failure to appear in court. So, sir, I'm going to go ahead and let you bond out today. Your bond's $250. Thank you.
Judge, speaking of Mr. Renko, he first wishes to ask the court if the court would be inclined to resolving this case and extending an offer of adjudication time served.
No, not taking into consideration his driving record and his failures to appear. I'm going to let him go see his judge. Thank you.
I was in
How about,
front of Judge Fine, Your Honor.
Excuse
I was
me?
in front of Judge Fine. I took care of this case.
Okay.
I took care of that. I was in front of Judge Fine, Hollywood Boulevard. I went before her and took care of it.
Judge Fine is on, I thought Judge Fine's in this building. Marty Fine? He's not on Hollywood Boulevard. No. Good luck, sir. Thank you. May I see Christopher Blackwell?
Judge, I know the court's not inclined to resolve the matter.
Right.
However, in speaking with him, he can't afford the $250. He's almost 70 years old, gets Social Security. Would the court consider releasing him on pretrial so then he could be supervised pending his court date?
No, sir. Thank you. Christopher Blackwell. Christopher Blackwell.
Blackwell, yes, sir.
Hi, sir. You have a warrant on a municipal ordinance violation. Open container of alcohol. State, I find probable cause. Tell me about Mr. Blackwell's priors. His name is Christopher Blackwell, but he's got aliases of Chris Capone, Little Capone, Chris Crip, and Capone Blackwell.
As far as local state priors?
Yes.
Circle the nose individually, press down hard.
Panhandling, 2017, grand theft, 08 with a Berg structure, a year and a day state prison, habitual offender. Failure to register as a career offender, 08, year and a day, HO. Cocaine, 08. Aggravated stalking, 01, 6 years state prison, HO. Goes on from there, Judge.
Yep. I'm going to let you, so I'm going to let you bond out. Your bond's $100. Good luck. Thanks.
Sir, I haven't been in trouble since 2008. I haven't done anything.
I understand.
I got ROR on this charge like 8 months ago.
Got it. Your bond's $100.
Then I went back
Thank
to
you.
Orlando, I missed my
May I see Amir Hood, please? Amir Hood.
He's approaching, Judge. Munis Corner.
Mr. Hood, good morning, sir. You've been charged with a municipal ordinance violation for trespassing. Court finds probable cause. State, do we have a criminal record on Mr. Amir Hood?
I'm sorry?
Mr. Hood, where are you from originally?
Polk County.
Polk? How long you been down here in Broward?
Since high school, maybe 10, 12 years.
Did you go to high school here up in Polk County?
Here.
Where?
Boyd H. Anderson.
And what are you doing for work now?
I work for Bonded Roofing. I'm a roofer.
Got it.
He's in misdemeanor drug court on the cannabis.
So I'm going to release you on your own recognizance. Do you still live on 6th Court in Pompano?
Yes, sir.
Okay. Just, I'm releasing you, ROR. You know, you got an open case for cannabis, now this. I don't know what's going on, but just, you know, kind of keep it straight until you go to court, all right?
Yes, sir.
Thank you. Good luck. All right. So what about Kevin Lee?
Mr. Lee is here at Main and approaching. Come on up, sir.
Okay. Mr. Lee, you've been charged with loitering or prowling. Court finds probable cause. The court notes the defendant is at large on his booking sheet. No address on his police report. State, do you have any criminal record?
I'm looking that up, Your Honor. I wasn't sure. I don't know if Mr. Romero had any concerns. I thought this might be an appropriate case for Judge Lerner Wren.
Judge, I haven't had the opportunity to review the PC affidavit, but I did speak with Mr. Lee. No concerns has been raised as of yet. He's 29 years old, been here his whole entire life, graduated Edison High School, class of 2008. He did advise me he's an Uber driver. He lives in Miami, where he rents a studio for about $600 per month. Judge, what he advised me is when he was arrested, he doesn't have his phone with him. He has no phone numbers memorized. Considering this is a second-degree misdemeanor, and if the state verifies that he has no prior contact with the criminal justice system, I'm going to be asking the court to consider a straight ROR on his behalf.
What about his local address? Do we have one?
1840 Northeast 174th Street,
Which city is that in?
Miami, Florida.
Could you repeat that for me, sir?
1840 Northeast 174th Street, Miami, Florida 33162.
Give me the zip one more time.
33162.
Okay, so, sir, I'm going to release you on your own recognizance today. I'm going to let you go to, they'll send you a notice. I'm going to give the clerk your address. I wrote it down here, and good luck. Thanks.
Thank you, sir.
Madam Clerk, I wrote down the address he gave me right on the front, all right? Okay, Jose Medina.
Judge bonded.
Okay, may I see Alex Vilsant?
He's here at me.
Hi, Mr. Vilsant. You've been charged with a battery, and that court finds there is probable cause. And State, do we have any criminal record on this gentleman?
Nothing local.
No? Okay. Okay. Anything you want to say, defense?
I do, Judge. From what Mr. Vilsaint advised me, this is his first arrest. He's been in medical reset now for about 3 days. He's 19 years old. He is working locally here at a tire shop located on Powerline in Fort Lauderdale, where he's been working at for 2 years, where he makes about $75 a day. He works, he lives in Oakland Park with his father. His father works at a restaurant. Judge, he's at the court to consider releasing him ROR. If not on ROR, then on standard pretrial release.
Okay. Sir, under the circumstances, the level of violence, court's concerned, sir, you got a drug issue. It says you're behaving erratically. And I'm concerned about the safety of the alleged victim. I'm going to order no contact with Ricky Butler, directly and indirectly. Stay 500 feet from him. Where he lives, works, goes to school. You're not allowed to possess guns or weapons. Any firearms or ammunition, your bond's going to be $1,000. Good luck. How about Vincent Rosier?
He's approaching, Judge. He has private counsel, Mr. Bruce Radikoff.
Bruce Radikoff.
Actually, he does not, Judge.
No?
Mr. Radikoff represents him on count 1 as a court-appointed attorney. Mr. Rosier has a no-bond hold on count 1, but Mr. Radikoff has not been appointed on counts 2, 3, or 4. And we would waive formal reading of the charges.
So, okay, so count 1 on this case is a no bond. No, wait.
It's a separate, Your Honor, it's a separate matter. He's being held on a no bond on a manslaughter.
Got it.
The public defender was conflicted off in that case, which clearly is not the same situation as the case.
Right. Got it. Okay, so, Mr. Vincent Rosier?
Sir.
Sir, don't tell me about what caused you to be arrested. Don't say anything about that, all right?
Yes,
Just
sir.
let me ask you. Do you have any money in the bank?
No, sir.
Do you own land or property in South Florida?
No, sir.
Do you have any means, financial means to bond out?
No, sir.
Okay. I do note that the defendant is registered, as I talked about earlier. I do note that it appears that he's transient, that he doesn't follow Florida statute regarding his duties to register. Anything the defense want to say on this?
I never. Judge, on my understanding, he's been in custody now for about 70 days. He's being held no bond on count 1. When he was out, his only form of income was disability, in which he got 7 months.
I'm going to order his bond on count 2, 3, and 4 is $25,000 per count. I'm going to order, if he makes bond, pretrial release, GPS monitor. That'll be a level 1. And that's it. Thank you. Court's concerned about the safety of the community based on his status. Thank you. How about Michael Babbitt?
Conte, Judge.
Hi, Mr. Babbitt. You've been charged with count 2 as a warrant on a felony, possession of methamphetamine. I set a bond on that, am I correct?
Yeah, it's a change of charge, Judge. What happened was he was originally, this count was originally possession of methamphetamine with intent to sell or distribute.
Right.
I believe a bondsman posted a bond. It was a $2,500 bond. He's been in custody on another count that he's county sentenced on.
Okay, so this count was originally 2,500.
It was originally 2,500. I have no objection to it being set at 1,000 because it's been.
So I'm going to leave you. I'm going to put your bond on this count at 1,000. All right.
And all his bondsman has to do is file an affidavit to stay on.
Right. Thank you, sir.
Thank you.
All right. What about Johnny Jones?
Hold on, Your Honor.
There you go. How you doing, Mr. Jones?
How you doing, sir?
Good. Count 10, 11, 12, 13 are all, 10, 11 are grand theft. 12 is a battery. 13 is a grand theft. And, excuse me. State, give me a highlight of count 1 through 9.
He's got a no bond hold on count 1.
Does he? So I'm going to set your bond on count 10, 11, 12, 13 after finding probable cause at $1,000 per count. Thank you. How about Antoine Mack?
Conti.
Your Honor.
Good morning. Good morning, Mr. Mack.
Good morning, Mr. Honor.
Sir, count 2 is grand theft. Court finds probable cause. What's count 1 on this, gentleman?
No bond on a robbery firearm.
Sir, your bond on count 2 is going to be $1,000. Thank you very much. Take care. Have a nice day. Whoops. May I see Michael Richardson, please?
How you doing?
Should be a Maine.
Maine?
Yes.
Hi.
Yes, good.
Mr. Richardson, you've been charged with count 5 grand theft. Court finds probable cause. What's count 1, 2, 3, and 4?
Top counts a robbery firearm with a $50,000 bond.
Sir, your bond's $1,000 on count 5. Thank you. How about Jonathan Davis Lambert?
He's here, main judge, approaching.
Okay, count 1, aggravated battery with a deadly weapon.
We're just here on 3 and 4, Your Honor. 1 and 2 was handled by Judge Levy yesterday.
Okay. Sir, possession of cannabis, count 3, 100. Tampering with evidence is 1,000 on count 4. Thank you. How about Luis Cabrera?
Your Honor, if we could put that on recall, he has a private counsel who had emailed me and said he would be.
Who's his attorney? Do we know?
I have the email here.
Adam Goodman, Judge.
Adam Goodman.
The number that in Miami had to cover, I guess.
Got it.
Yeah,
okay.
I guess.
Sir, stand by. You can have a seat. We're going to contact your attorney. I think is going to be on their way. Okay. What about Miguel Gonzalez?
Mr. Miguel Gonzalez is here present, Judge, at Maine, and he declined the service of public defense.
Count 4 should be 1,000. Right. Got it. Does. Okay, Mr. Miguel Gonzalez. Count 1, 2, and 3 are all violations of probation on felonies. Count 4 is a warrant on a traffic matter. License suspended. That's a $1,000 bond. So you can be held no bond on count 1, 2, and 3. Count 4 is 1,000. All right. Thank you.
When will the first 3 get a bond?
Those are no bond because they're violations of probation from your trial judge. Your trial judge ordered no bond. All right.
When I get court?
Excuse me.
When I go to court, that'll be taken
You
care
go
of?
to court on the 18th and on the 22nd. All right. Thank you.
Thank you.
You see Troy Towns.
He's here present, Judge.
Mr. Towns, petty theft. Good morning. Court finds probable cause. State, do we have a criminal record on Towns?
He pled out a theft September of last year. Possession of PVP 2015, 38 months state prison. Strong arm robbery 2010 with a VOP, 38 months.
So he went to trial in 15, went to prison in 15 and 10, right?
Yes, they were. They ran concurrently in 2015.
Got it. Okay.
Judge,
go ahead. Sir.
And speaking of Mr. Towns, normally he could contact his mom too. His mom could, his aunt could post his bond, but she is out of town, so that's going to pose a problem. Having said that, he's been residing here in South Florida for over 8 years. He works at Home Depot. He's been there for about 5 years, making $327 per week. He's asking Judge to consider releasing him on pretrial release, Judge.
I understand. Sir, do you have any money in the bank?
Yes, sir.
How much do you think you have?
$13,000.
Okay, I'm going to let you bond out today. Bond $750 based on the facts of the case, your criminal record. You've gone to prison on possession of PVP and strong arm robbery and a prior petty theft. Good luck. Don't go back to that Walmart. Thank you.
Your Honor, before we go into the next case, we're on the phone with Mr. Cabrera's attorney. He wants to know can he either appear telephonically this morning or physically this afternoon?
Let me look here.
Say DV.
It's up to him if he wants to do it by telephone, or I can put it in the afternoon, whichever he wants.
We'll ask. He's asking if it could be telephonically. I have his number.
All right, may I see Luis Cabrera? Stand by one moment. Come on.
Yes, Your Honor. Good morning.
Sir, I have your attorney, Mr. Goodman, on my telephone. We're going to have a telephonic conference right now, but I'm going to remind you, you have the right to remain silent. You should utilize that right. Do not comment about what caused you to be arrested. Allow your attorney to speak on your behalf, but if you make a comment about what caused you to be arrested, anything surrounding that, everything's being reported, be used against you one day. Do you understand that?
Yes, Your Honor.
Got it. Okay. Good morning, Mr. Goodman.
Good morning. Good morning, State.
So we have Adam Goodman on the telephone, attorney. Mr. Goodman, your client's been charged with count 1 criminal mischief, over $1,000, a battery, misdemeanor, and an armed trespassing of I think it's a dwelling. Am I correct?
It was a dwelling, but under the trespass statute, a structure would still apply.
Okay. So
yeah, there's no firearm, is my understanding. That's an error.
I don't think there ever was a firearm allegation. I don't have it, but it does say armed.
Well, Your Honor, I can pull the information.
I'll just give you the highlights. It was allegedly found that a Tiffany Alexandra Fu, there's a domestic battery, Angela Marie Vasco, and Mario Alonso were all alleged victims. It says that Luis Cabrera exited a vehicle, walked up to the front door of the residence, opened and entered the house. He unlawfully entered the house. Once inside, he made contact with a Miss Vasco, Angelica Maria, and it says that he began cursing at Vasco and spit in her face. He exited the residence and began damaging a vehicle. And it says he climbed onto the hood and smashed the front windshield with his feet by jumping and kicking down on it. Says the vehicle had visible damage. The police officer estimated around $5,000 worth of damage. So,
Your Honor.
Okay, go ahead, state.
I reviewed the matter. He was just charged with trespass, not armed.
So it's a trespass, simple trespass, sir. Okay, so anything you want to say on behalf of your client, Mr. Goodman?
Yes, Your Honor, he's been in custody for roughly, I believe, a week. He became aware of the warrant, and once he became aware of the warrant, he turned himself in. He turned himself in Miami-Dade, and while in Miami-Dade, he sat there for over a week waiting to be able to get a bond. And even though it's a bondable offense, he sat with that no bond hold for over a week. And this is someone with no priors. There's no one who was physically injured. It's an older case in the sense, so I believe the state's already filed an information, which is why the charges have been changed. So because of that, I would simply ask for maybe like $1,000 bond on the felony, and then a $500 bond on counts 2 and 3, the misdemeanors, with stay away orders from the victims, and that would be that. State,
does he have a criminal record?
He does, Your Honor. First, in 2015, I'm showing an arrest in Dade for domestic violence battery. It appears that was dropped. He was I'm showing a conviction out of Dade from 2012 for burglary with assault or battery. He was sentenced to 11 months and 29 days in county jail.
Okay.
And I'm not privy to the history. I just ran them real quick, so I can't say what is correct or what is not correct. I just know that these allegations, as far as they're concerned, he turns himself in.
I understand.
He's been in custody, so he's not a flight risk. I don't even think the victims, as far as I know, are interested in this case at this point, but I can't opine for sure. So I think a $1,000 bond on count 1 and 500 on counts 2 and 3 would be sufficient to ensure his appearance in court and protect the community.
Let me ask you, while the court's not only concerned about the community, but concerned about the alleged victims, he does have a history of violent behavior. He's been arrested for a domestic battery, even though it was dropped. As you know, the statute says courts can consider even dropped domestic batteries. So the court also notes that he did jail time and was convicted on a prior violent crime, burglary with assault or battery. Did over, I think, about a year in jail in Dade County on that. So he has a history of violence, and the court wants to know who's going to help bond him out of jail today.
He has a significant other. No, I know I'm on the phone. He has a significant other who would be the one who would be bonding him out.
Does he have money in the bank that you know of?
Not that I know of.
How long has he lived down here in South Florida?
You could ask him.
How long have you lived here, sir, South Florida?
My whole life, sir.
All right. Are you currently employed?
Yes, sir.
What kind of work do you do?
Well, I'm a welder.
Do you own land or property here in South Florida?
No.
No. Who's going to help bond you out?
My wife.
Okay. Do you have kids?
Yes, sir.
How many?
18 months.
18 months? All right. I'm going to go ahead and set the defendant's bond on the criminal mischief on count 1 at $2,500. I'm going to set the count 2, the battery, $2,500, and I'm going to release some ROR on count 3. His total bond today is going to be $5,000 based on his criminal record. Facts of the case: court's going to order that the defendant have no contact, directly or indirectly, or with any of the property of the following people: Tiffany Alexandra Fu, Angelica Maria Vasco, and Mario Garcia Alfonso. You must stay 500 feet from them, where they live, work, go to school, any of their property, any of their children. You're not allowed to possess guns, weapons, firearms, ammunition while you're out on release. Thank you, Mr. Goodman.
Thank you, Your Honor.
Yes, sir. Bye.
Thank you, Your Honor.
Yes, sir. Okay. What about Ron Boyd? No, I'm sorry.
Mr. Boyd is here
Bond
present,
Boyd.
Judge O'Malley. He's approaching.
Hi, good morning, Mr. Boyd. So you've been charged with aggravated stalking violating pretrial release condition regarding dating violence, and you have a arrest warrant on count 3. Are any? Tell me. So I set bonds on count 1 and 2, but count 3's already been set. Oh, that's a purge amount on count 3. Am I correct?
Yes, Judge.
And that is for 600. What is that? $815.
$815.
So, sir, you have a purge amount on a civil matter, which is $815, and you have to, no matter what happens on your 2 criminal charges, you're going to have to pay that. I think you have a right to go before the judge, be brought before your judge on that, but that's on a different matter. So, count 1 is the aggravated stalking. Count 2 is the violating pretrial release. The court, like I say, finds probable cause. State, do we have a criminal record on this gentleman?
Yes, Your Honor. He's currently out on bond, and it's referenced in the arrest warrant affidavit for felony battery with a prior conviction against the same alleged victim in this case. The no contact order in that case is the basis for charge 2 on the warrant, Your Honor.
So these charges would violate that release.
Yes, and specifically charge number 2 in the arrest warrant.
Right.
It's based on violating that no contact order.
Okay, what is the case number?
17-13783 CF10A.
Got it.
Additionally, 2010 attempted robbery with a weapon. He violated probation, was sentenced to 3-year state prison, and he had a battery conviction in 2005. That was the underlying offense for the felony battery that he's out on now.
Got it. Okay. Got it. Okay. So any defense, would you like to make a comment at this time?
Yes, Judge. I understand that he's out on a case, Judge. I believe court is thinking about taking action. I'd ask at this time that the court not revoke his release and hold him no bond, if anything, to modify and place him on a form of supervision with a pretrial with a monitor.
Right.
Judge, on the new law offenses, I'm going to be requesting $1,000 bond each count. He's 33 years old, been here his whole entire life. He is working. He works for a funeral home where he's been working there over 10 years, making about $300 per week. He lives here locally in Fort Lauderdale with his family. So, Judge, that's what the defense is requesting at this time.
I understand. Sir, based on your criminal record, the facts of the case, court notes that you're out right now on a felony battery. And while you were out, you allegedly committed the acts you're charged with today. The court notes you do have a history of violence. 2010, an attempted robbery with a weapon that you went to Florida State Prison on. And count 5, a battery. So you have a history of violence. The facts of the case, court's going to set count 1 on this case at $50,000. Count 2, the court's going to set that bond at $50,000. Count 4, the writ of arrest, $815 purge amount. The court will revoke your bond on 17-13783 CF10. The court will order that you have no contact directly or indirectly with the alleged victim in this case. And the name of the individual, which I'm going to say right now, that's a Miss Webb. Do we know her first name?
Yes, Judge. 1 moment.
Carla Webb. No contact with Carla Webb directly or indirectly. No third-party contact, no direct contact. You must stay 500 feet from her at all times. You're not allowed to possess any guns or weapons, firearms, or ammunition. Sir, let me stress for you, because that's part of the facts here, is that you continue to contact her. No calls from the jail, or any other manner to contact Ms. Webb. You can't have a third party do it for you. Okay? Thank you. Okay. Robert Chappell.
Mr. Chappell's here, Maine.
Okay, Mr. Chappell. Sir, you have the right to remain silent. If you give up that right today, whatever you say can and will be used against you. Do you understand that, Mr. Chappell?
I do understand that.
Okay, Mr. Chappell, you've been charged with, do you have a private attorney, sir?
I do on a previous case, which I'm also going to be violating probation apparently with this arrest. So I do for that case, but I've not retained him for this matter.
Who is that attorney?
His name is Mark Lowry.
Okay. Would you like me to contact him for you to this morning?
I think that at this point, I don't know what I'd like to do. I have not really had the opportunity to contact him or anyone else regarding this matter.
So I'll just proceed with the public defender next to you, okay?
Okay, thank you.
Okay. Sir, you're charged on count 1, arson in the first degree of a dwelling with people present. Count 2, it's a violation of probation. You're on probation right now for aggravated battery with a deadly weapon. Count 1, the court's going to find probable cause. Defense, do you have any comment about bond on count 1?
I'll wait till State goes first, Judge.
Okay. State, does he have any priors other than count 2?
One moment, Judge.
Excuse me.
Does pretrial have anything, please? Your Honor, while that's being looked up,
2015 aggravated battery causing bodily harm.
Yeah, that's count 2. Got it. Anything else?
There was a 2017 violation of an injunction.
2017 violation of an injunction.
Against domestic violence, yes, Your Honor.
Got it.
He was adjudicated on that.
Got it.
He failed to appear during the pendency of that case.
Got it.
And then, of course, what is in front of the court.
Got it.
And, Your Honor,
anything else?
I'm just checking one thing. Okay. I was just checking to see if the violation involved the same victim as in this case, but it did not. Your Honor, what I would be requesting is, in addition to whatever bond the court deems appropriate, based on the specific allegations of this case, the violent offense he's on probation for, and a recent conviction for violating a court order to stay away from someone, I'd be requesting a GPS monitor on count 1 in addition to any bond you said.
Got it. Okay, defense, anything you'd like to say?
Judge, from what he advised me, he does have money in the bank. He has roughly about $200, but he owns no property. At this time, he is looking for stable employment. He's 29 years old. I do realize he's being held no bond on count 2. So, Judge, I might ask you to take that into consideration, determining reasonable release conditions.
Got it. Got it. Okay, so, sir, the court notes that approximately 3:30 in the morning in the city of Fort Lauderdale, January 16th, you were in someone's dwelling, and while you were there, the alleged victim noticed smoke billowing from his home, grabbed a fire extinguisher, was able to make it inside the home. He discovered his bathroom closet was on fire, and the house was filled with smoke. He attempted but failed to extinguish the fire, contacted fire rescue, and the court notes that you had just been in that bathroom moments earlier, and it was clear to the police that you were the one who started the fire. The court notes that you're on probation right now for a violent crime of aggravated battery, which you're going to be held without bond on. The court also notes you have a history of violating an injunction where a court order told you to stay away from someone, 2017. And on that case, you failed to appear in court. So you have a history of failure to appear, a history of violence, and now you're allegedly attempting to burn someone's home down. So the court's going to set your bond on count 1 at $250,000. Count 2, you can be held without bond. If you do make bond on count 1 eventually, pretrial release, GPS monitor, that'll be a lockdown level 1. The court will order that you have no contact directly or indirectly with John Acomb, A-C-O-M-B. No contact with him directly or indirectly. You must stay 500 feet from him at all times. While you're on release, I'm going to order no, if you do make bond, no You're not allowed to possess any guns, weapons, firearms, or ammunition. You're also not allowed to possess any accelerants, any ignition, no matches, no lighters. You're also not allowed to have any kind of accelerants other than the gasoline in your car. Other than that, no other accelerants. Thank you, sir. There you go. Or combustibles, I guess. Okay? There you go. Okay, may I see Keandre Owens?
Mr. Owens is here, President Main.
Hey, Mr. Owens, grand theft auto, 2 counts, count 3 and 4, petty theft. And are these warrants?
Yes, on Mr. Owens, the cases, the bonds should be set at $1,000. He came in from DeSoto,
right.
CI, on transportation.
Got it.
But the cases, it should be 1,000 on 1, 2, 100 on 3, and 100 on 4.
So tell me what 1 and 2 are again.
1 and 2, 1,000.
Got it.
3 and 4.
Got it. Okay. Mr. Owens, count 1 and 2 are $1,000. Count 3 and 4 are 100. Your total bond's $2,200, sir. Good luck.
Judge, we have nothing to add as far as the monetary bond. He's serving a prison sentence. He's been sentenced to 36 months. He just wants to know when was the alleged date of incident on this
Hold on.
Case.
Give me a moment. I'll see if I can tell him. August 14th, 2016 at Pembroke Pines. LE Fitness Gym. All right, thank you. May I see Craig Ricks?
He's approaching.
Good morning, Mr. Ricks.
Good morning.
Sir, you've been charged with possessing a weapon by a convicted felon, possessing cannabis, which is a felony amount, count 2. Count 3 is possession with intent to sell, deliver the cannabis. Count 4, possessing drug paraphernalia. Now, let me just look at something real quick here. Okay, I do find probable cause to count 1. At first, when I read this, I wasn't sure that it was a weapon, but I had a conversation with the state in open court, and it says you were in possession of a purple CEW, Charlie Echo Whiskey. I didn't know what that was, but I've been informed. I've been informed that that is short for a stun gun. So, what does it stand for, State?
It stands for conducted energy weapon. It's an electronic weapon.
Okay, so court finds probable cause. Does I know Mr. Ricks has prior. State can tell me what he's also been known as. So his name is Craig Ricks. He's been known as Craig Nixon, Craig Hill, Craig Lankins, Craig Larson, Victor Morris, and Craig Larceny.
We'll start with Broward priors.
Okay.
01, possession of cocaine. 2000, 3 counts of perjury during an official proceeding. 5-year state prison as a habitual offender. Cocaine 2000, cocaine 2000, cocaine. It's mostly drug priors. It's a very old burglary. I'm not going to get into that. Seeing if there's anything worth noting from out of county. All right, out of Hillsborough County, possession of cocaine, 2 separate cases in 08, and an attempted strong-arm robbery. In 07, he was sentenced to 18 months state prison.
Got it.
This would be the most.
Okay, anything from the defense?
Yes, Judge. As you heard, he does have a record. However, he's been over 10 years clean. He's 54 years old, been residing in Florida his whole entire life. He is working right now. He washes cars for a living. He's been doing that for about 2 years, where he makes about $45 to $50 a day. He lives in Pompano Beach with his mother. His mother is on disability, so he does not believe she has the financial resources to post his monetary bond. I'm going to be asking the court to consider releasing him on pretrial release.
Got it. Okay, now, let's see here. Sir, I do know you have a lengthy drug history. You've been to prison twice, once for 3 counts of perjury, 1 for attempted strong-arm robbery. You have a prior burglary that's a bit dated. I'm going to set your bond on count 1 at 1,000, 2 at 1,000, 3 at 1,000, and count 4, I'm going to release your ROR. So your total bond today is 3,000. Thank you. How about Missy Elvis Pereira? Do you have
Bonded.
Elvis Pereira? What is that?
Bonded.
Bonded? Thank you. You okay over there, Miss?
I am.
Thank you. All right. Okay, may I see Anthony McBride?
Judge, he's here at Maine, and we're going to be waiving formal reading of the charges.
I understand. Good. Okay. Mr. McBride, you have the right to remain silent. If you give up that right today, whatever you say can and will be used against you. I strongly suggest you don't make any comments, anything you want to say, save it for your attorney in a private meeting after this hearing. Everything is being recorded. Do you understand what I've explained, Mr. McBride?
Yes, Your Honor.
Good. Okay. Has the public defender there made you aware of what you've been charged with, sir?
Yes.
Okay. Now, the state, does this defendant have any criminal record?
Your Honor, I'm checking that, but I am going to be making a request of the court. One moment. On count 1, I'm requesting that the court keep the bond in place. On count 2, kidnapping is a punishable by life offense, and I am going to be asking the court to make a finding of proof evident or presumption grade,
okay,
and ask that he be held no bond on that. If it please the court, if I can hold off on advising the court of any priors until you make that ruling, I don't want to have the impression that you could be might be
right.
influenced.
Okay. So count 1 is bondable. Count 2 is not a bondable offense if there is proof evident presumption grade found. So does anybody have a comment about count 2?
Yes, Judge. Proof evident presumption grade is the highest standard of proof that we have in the criminal justice system. It is our position that the state has failed to meet that very high standard. I have been provided with a copy of the warrant in Mr. McBride's case. I have reviewed it, as I'm sure the court has as well. Our position is that the contents of this document do not establish proof evident presumption grade. The state has called no witnesses. They've introduced no evidence. No testimony has been provided to the court. They're relying solely on a written document authored by a police officer to justify the charges for which Mr. McBride was arrested. So we would ask the court to set bond for Mr. McBride. We do not have a probable cause argument, but we do have a proof evident presumption grade argument.
Got it.
If over defense objection, the court feels that proof evident presumption grade has been met, we would encourage the court to exercise its discretion and set bond for Mr. McBride.
I understand. The court today has reviewed the warrant to arrest, the affidavit, and the court notes the facts which are alleged within that affidavit. The court notes that the alleged victim in this case, the initials of RC, Romeo Charlie, was very specific. The court notes the detailed facts she allegedly gave the police and the investigator. The court notes the consistencies throughout her alleged statement to the police, and the court is confident at this stage that there is proof evident, presumption grade, that the defendant in fact committed count 2, which is kidnapping, and the court will order the defendant to be held without bond until further order of the court. Now, the court turning to count 1, what say the state or their priors on this defendant?
Your Honor, I want to advise the court. He has a pending case that doesn't violate the. This does not violate the release conditions because this occurred before he was arrested.
Right.
But He does have a pending aggravated assault against a law enforcement officer, aggravated fleeing and eluding at a high rate of speed with a DWS habitual offender. He also had from last year possession of cannabis felony amount. 2011 strong arm robbery with a violation of probation.
Okay, hold on. Okay. What year was that?
The strong arm robbery?
Yes.
2011.
Got it.
He violated probation, sentenced to 364 days.
Got it. Okay. Okay. Now, anything defense want to say regarding count one?
Judge, as I see the bond, which is currently set as $100,000, Mr. McBride is working. He works at a restaurant, an Italian restaurant, where he's been there for about 3 months. He's a cook. He makes $11 an hour. There's no monetary way he's going to be able to post that $100,000, so I'd ask you to take that into consideration.
I understand. Okay. Sir, the court notes that the alleged facts of the case I'm not going to delve into right here, but I'm going to just make a few comments that it does look like this was allegedly planned. It looks like the defendant, let's see here, there's one other thing I want to just point out. The court is concerned about the safety of the community that the defendant allegedly removed the victim from a public bus. The court is concerned that it was planned. The defendant got someone else to allegedly drive him to the location to remove the alleged victim off a public bus, and the defendant allegedly moved the victim to another location. And the court notes the facts contained within the arrest warrant. The court's very concerned not only for the safety of the alleged victim, RC, but the safety of the community. Right now, the defendant has an open case of aggravated assault and aggravated fleeing and eluding. The court also notes the defendant has a prior felony cannabis charge, and the defendant has a prior violent charge, violent conviction for strong-arm robbery with a violation of probation. The court is concerned about the young people in the community, and specifically the alleged victim, who is not 18 years of age yet, RC. The court's going to set the bond on count one at $500,000. The court will order no contact directly or indirectly with a female, a teenager, with the initials of RC, Romeo Charlie. No contact directly or indirectly. The court will order that if the defendant eventually makes the bond of $500,000 on count one, he have a GPS monitor, and it will be a level 1 lockdown. Let me see. And I think that's it. Thank you.
Yeah, the only thing Mr. Bride wishes me to address the court as far as the prior that the court referred to as far as a violent offense being adjudicated, my understanding is, and speaking with Mr. Bryant, adjudication was withheld. So I don't know if that makes a difference with the court as far as modifying.
He had a violation of probation. So
and that's still,
I'm
you can still keep it withhold.
Okay. Sir, whether or not you were a withheld adjudication or adjudication on it, it makes no matter to the state. It's a prior violent criminal offense with a violation of probation. Thank you. Okay. Do you need me for anything? No? Okay. How about Anthony Darling?
Mr. Darling is here, present, approaching. Come on up, sir.
Good morning, Mr. Darling. So you've been charged with possession with intent to sell, deliver cannabis, lording, or prowling. The court finds probable cause. State, does this defendant have any criminal record?
2012, possession of firearm by convicted felon, ag assault firearm, discharging a firearm from a vehicle, sentenced to 3 years state prison as a habitual offender, 2012, possession of cannabis with intent to sell or deliver. 2011, violation of a pretrial release condition, no victim contact. 04, dealing in stolen property, grand theft auto, VOP, just under 21 months state prison. 04, aggravated battery against a pregnant victim, VOP. And I'll leave it at that, Judge.
Got it. Okay, anything from the defense regarding bond or release conditions?
Judge, at this time, nothing recent, but at this time, nothing to add from the defense.
Got it. Got it. Okay, so I'm going to go ahead, sir. I do know you have an extensive criminal history, prior drugs, and I'm going to go ahead and set count 1 at $1,000. I'm going to set count 2 at $1,500. Your total bond today is going to be $2,500. And I'm going to let you bond out of jail, sir. Good luck. Thank you. Okay. May I see Michael Habersham?
Judge, I've been trying to reach Michael Weinstein. Mr. Habersham had indicated to us that Mr. Weinstein is his attorney. I'm waiting to hear back. Maybe you could recall it.
Okay. Yeah, I understand. I understand. It's Mr. Weinstein. Am I correct? Okay. Sir, has anybody been able to reach Mr. Weinstein?
I've spoken with his office twice this morning, most recently about 10 minutes ago, and they're reaching out to him. He is in the courthouse, but he did not respond initially.
Just give me I may have his number right here.
I have the office number. I don't have his cell phone number.
Hold on one sec. No, I thought I may have his number. So what would you like to do? Why don't you just have a seat, and then we'll call you back up if he gets in here, all right? Just have a seat. How about Sean Feather?
Bonded?
Bonded? How about Dwan Jackson?
He's approaching.
Okay, sir, you've been charged with grand theft. Court finds probable cause. State, do we have a criminal record on this gentleman?
Mr. Jackson is being supervised by pretrial services. He actually was wearing an electronic monitor.
Right.
What is the data incident on this?
January 16th.
There we go. The defendant is being supervised on case 17-2381 CF10A, possession of lorazepam, resisting without violence, petty theft, and possession of buprenorphine. Case number 17-2929 CF10A, possession of alprazolam. Case number 17-14781, grand theft in the 3rd degree. And lastly, case number 18-3941 CF10A, possession of cocaine and petty theft. Based on this court's finding of probable cause, we're going to ask that his pretrial status be revoked in these 4 cases. It should be noted that he is in Judge Port's division, Your Honor.
Got it. Okay, sir.
Before you take any action, my understanding, Mr. Johnson, on this new law offense, he's looking forward to having his day in court and contesting it. Sure. It's his understanding that he actually did not take anything. Judge, he's been on that case. He's been going to court, I believe, 5 or 6 times already. He has a public defender's office representing him on that case. I'd ask you to defer to the division judge, see if that prosecutor wants to make its own motion to have his release conditions revoked. But I'm going to be asking that the court at this time not take any action.
I understand.
I have a receipt on that. On items.
Right. Okay. Got it. Sir, I'm going to set your bond today based on facts of the case at $2,500. And I'm going to go ahead and revoke your pretrial on case 17-2929 CF10, 17-14781 CF10, and 18-3941 CF10. You could be held without bond on all those cases. You'll see your judge, I imagine, in the next few days. Thank you, sir. Jamal Wilson.
Mr. Wilson is here present at Maine.
Hi, Mr. Wilson. Possession of methamphetamine and 3 counts of possessing drug paraphernalia. Court finds probable cause. State, do we have a criminal record on this gentleman?
He has possession of methamphetamine from last year, pled out a month ago. Another possession of methamphetamine last year, also pled out December 17th.
Got it. So we're 1 month exactly since the defendant last pled out a felony methamphetamine case, and he had a prior one last year too. So two last year.
They were both pled out on the 17th.
Oh, they both pled out 1 month ago, and now the defendant is back again on a methamphetamine possession case. So, are there anything from the defense?
Yes, Judge. And speaking of Mr. Wilson, he's looking forward to disputing these charges. My understanding is, from what he informed me, he contacted law enforcement. There was another individual there. He's claiming that is not his, I guess, alleged items, and he's looking forward to proving his innocence, Judge.
Let me just read to you the last paragraph. Post Miranda, the defendant did admit the substance to be crystal meth. The crystal meth was field tested positive. Let's see here. The defendant was okay. So that's the last paragraph.
It also notes that body-worn camera was in use.
Right. Okay. Anything else?
So, Judge, he's asking for a straight ROR on this matter.
That's not based on your criminal record and your recent history. Sir, if anything else, I got to tell you, I'm worried about your health. I mean, your own well-being. It seems like you have a pretty serious drug problem. You want to tell me about his ability to make bond? And
Judge, Mr. Wilson is asking me to stress again that he's the one that contacted law enforcement. He wanted to seek help for his friend.
Right.
And, Judge, he actually knew what the items were because he was telling the police what the items were.
Right.
That belonged to his friend. Wait, that belonged to his friend. So as far as the post-Miranda statement that the court read off, that still doesn't negate what Mr. Wilson has advised me. So, Judge, he's asking me once again to ask the court for a straight ROR.
You're not going to have a straight ROR, so that's off the table. What about his ability to bond?
from what he advised me, there's no one he can contact to post his bond, and right now he's not working. He's looking for work, but right now financially, he has no one to put bond.
Got it. Sir, based on your recent arrest here for meth, I'm going to go ahead and I'm going to raise your bond at $2,500. Your recent plea, I guess, you took, I'm going to set 2, 3, and 4. I'm going to set count 2 at 1,000. I'm going to release your ROR on count 3 and 4. And would you like me to, can I put him in some type of drug unit in the jail, perhaps? Can I do that?
If he wants, you can refer him or to.
If he wants to do that, let me know, all right? Thank you.
Yes, Judge, but he's saying no thank you. He doesn't have the...
All right, good luck, sir. I'm going to move to the next case. Thank you. Steve Hippolyte.
Medical reset.
Okay, let's reset Mr. Hippolyte until tomorrow. State, I'm inclined to go ahead and find probable cause today.
I think that was already done.
Was it?
Okay. Is it checked off on the findings, Your Honor?
Yes, it is. Med reset tomorrow morning on Mr. Hippolyte. Okay, Jerome Jones.
Conti.
Judge, he's at the main. He's at courtroom 5750.
Okay.
Your Honor, here's what's happening.
Go ahead.
Based on the administrative order,
right,
it rules that anyone that's arrested on a felony capias is to be brought to their judge the next day.
Right.
The problem is when he was supposed to be here yesterday, he was in front of his judge for arraignment on these charges. So I asked the judge, and it said status the next day. I asked the judge asked the clerk, take off that status, because what my concern is what has happened. Instead of bringing him here, they brought him for the status that was said yesterday. My concern is we reset him for tomorrow. He's going to be at the status that's being reset again. Can we maybe get him here this afternoon?
I'll be happy. Can we? Where is he? Which jail is the defendant?
He's at the
Conti.
Conti, Your Honor.
Yeah. Well,
he's at the downtown right now.
Is there a way we can order him to go from his courtroom in the courthouse to maybe Maine? Can we do that? The defendant.
He's downtown for his status.
In whose courtroom?
So you want him on PM?
PM docket. He's currently in the courthouse somewhere.
Yeah, they have to call and get him brought over to.
Can they do that? Can somebody make that happen?
If you want to set up for PM.
Okay, let's reset Jones for PM.
He's before Judge Colruyt right now.
Okay, could somebody contact Judge Colruyt's courtroom and get him over here? Thank you. Okay, what about Shamar Sheely? Sheely?
Judge, I spoke with him earlier. He decided to decline our invitation to remain.
And, Your Honor, I was just going to request...
Sheely, is he over there? Is it Conti?
He's at Conti, Judge.
Got it.
Okay. It's a change in charge, Your Honor.
He's a refusal, Your Honor.
Refusal?
Yes, Judge. He declined our invitation.
I was going to be requesting that the court set the $10,000 bond in place. You can see while he was arrested for burglary of an occupied dwelling, Your Honor, we filed it as a burglary of a dwelling. It's a technicality because it's still the same level of offense.
Right.
As you can see in the PC, clearly the factual allegations involved that someone was home. We just didn't file it that way, so we don't have the extra element that we have to prove.
So I'm going to go ahead and let me look here. Okay, so I'm going to set count 16 at 10,000 and count 17 at 5,000, all right? There you go. Thank you. How about Glenn Jones?
Conti, Your Honor.
Hey, good morning, Mr. Jones. Sir, you have the right to remain silent. If you decide to give up that right and you make any comments about your arrest, you will, whatever you say will be used against you. I strongly suggest save any comments you have for your attorney in a private meeting. Do you understand that, sir?
Yes, sir.
Okay, sir. You're charged with, it's a straight robbery. Am I correct, sir?
Your Honor, yeah. When he was first arrested, he was charged with robbery with a weapon. The state filed an information for robbery with a deadly weapon. I provided the court with a copy of the original probable cause affidavit.
Right.
As you can see, the description of the knife one, it clearly would satisfy, based on the physical description of deadly weapon, and also based on the manner of use in the report. Now, because he is charged with a punishable by life offense, I'm going to be requesting the court to make a determination for purposes of this hearing only that proof evident or presumption great exists and that he be held no bond.
Okay, the court, sir, you've been charged with robbery with the deadly weapon. And the court has reviewed the probable cause affidavit. It says you work at the Broward County Fair with another gentleman named Joaquin Solomon. And it says in the sleeping quarters, you approached the alleged victim from behind and grabbed him, put your arm around his neck, placed a knife to the right side of his neck. You asked for the money. He turned, grabbed your hand, and it was a struggle, and he received cuts. It says you were stabbed in the neck during the struggle, and that during the struggle, you were able to steal over $1,000 from the alleged victim. And it says that you fled the area, but I did note that, let's see here, you were treated by fire rescue for the stabbing. You had a lacerated carotid artery. The police found evidence of the stabbing in the trailer. Defendant gave a sworn statement. Okay. They found a black nylon knife sheet. Got it. Okay, so any comment from the defense regarding proof evident presumption great?
Yes, Your Honor. We would object to the court making a finding of proof evident presumption great at this time. It's the highest standard we have in the criminal justice system. The state has introduced no testimony. They've called no witnesses, introduced no physical evidence. Our position would be that the state has failed to meet that very high standard, and we would ask the court to set bond for Mr. Jones. If the court does find proof evident presumption great over our objection, we would ask the court to exercise its discretion and set bond for Mr. Jones.
Okay, the court taking in consideration the argument of the defense counsel of the state, I'm going to go ahead and the court has reviewed the probable cause affidavit. The court notes the specificity, the evidence found, the injuries you allegedly sustained, sir. The court does believe at this time there is proof evident presumption great. The court will order you to be held without bond until further order of the court. The court will also order you have no contact directly or indirectly with Joaquin Solomon. No contact directly or indirectly. Thank you very much. Okay, Mr. Weinstein, how are you?
Judge, how you been? It's been a long time.
Good, yeah, but I saw one of your family members here recently.
In magistrate court?
No. No, I attended a funeral. I saw actually two of your family members there.
Oh, Skips?
Yeah, Russell Thompson.
Oh, right. Yeah.
Okay, Michael Habersham, please.
Yes.
Mr. Habersham, good morning, sir.
Good morning, Judge.
Good morning. You're being represented by Mr. Weinstein. Please do not make any comments about your arrest or any facts surrounding your arrest. Whatever you say can and will be used against you. Allow your attorney to speak on your behalf. Do you understand that, sir?
Yes, sir.
Okay. Good morning, Mr. Weinstein.
Good morning, Judge. Good morning, Michael. Can you see me and hear me?
Yes, sir.
Hi, how are you?
Good.
All right.
Mr. Weinstein, your client's been charged with 2 counts of possession with intent to sell, manufacture, deliver. Count 1's cocaine. Count 2 is heroin. Count 3, possession with intent to sell, deliver alprazolam. Count 4, possession with intent to sell, deliver, I guess that's fentanyl. So, do you have any argument about probable cause at this time?
Judge, I don't have probable cause argument regarding the 7 baggies of the heroin, but I do have a probable cause argument of 6 capsules of fentanyl. I mean, if you just have 6 capsules, that could easily be possession. So I do have a concern that they've charged possession with intent on the fentanyl.
Do you have any argument on that, State?
Well, Your Honor, first of all, I would know one doesn't need a small amount of fentanyl to be able to deal in it. A few granules can have the desired effect and ultimately kill. I think taking it into totality of the circumstances with all the other drugs and the amount of cash that was found in denominations consistent with drug sales, that is enough for probable cause.
Right. Mr. Weinstein, I'm going to disagree with you. I do find that there is probable cause, but I do note your objection for the record. Mr. Weinstein, do you have any comment about bond? Well, let me ask you this before we get there. State, does he have a criminal record?
Yes, 2013 possession of cocaine, 08 possession of cocaine, 06 possession of cannabis with intent, 03 possession of cocaine with intent.
What year, 03?
03, yes.
Got it.
An aggravated battery in 01. Everything else was drug-related, Your Honor.
Okay, so, Mr. Weinstein, your client, from what I can see, has 3 prior cocaine cases, a felony cannabis case, and a prior aggravated battery.
Well, I'll point out, Judge, let's talk about the positive. Michael is a lifelong resident of South Florida. The only violent arrest that the state is alleging occurred nearly 20 years ago. Everything else has been nonviolent. He does have a local place to stay. He has children here in South Florida. He has been represented by me in the past, so clearly he knows that he's got ties even to the courthouse and to me. He's not going anywhere. He's not going to capious. These charges, I know that suppression, Fourth Amendment issues are not your purview right now. But I think the court should take into consideration that there's nothing in the arrest report that says why the canine officer responded to the scene. I mean, so there might be suppression issues later. Again, I know that is unrelated to what you're going to do today, but I think you should take into consideration that we might have a motion to suppress later on. So having said that, Michael doesn't have capious issues, has a place to stay, lifelong resident of South Florida, has children here. I would ask that you consider as follows. I think ultimately the state is going to downfile that possession on the fentanyl. So I would ask that you consider dropping that from the $2,500 down to the standard bond of $1,000. And then because he doesn't have any capious issues and there's really no violence issues, I would ask that you drop the other two from $2,500 to $1,500.
Mr. Weinstein, I do consider your argument. What I'm going to do is I'm going to, based on his criminal record, but I mitigate the bonds based on your record and some of the legal issues you pointed out. So I'm going to set count 1 and 2 at $2,500. Count 3 will be $1,000, and count 4 I'm going to reduce to $1,000. Right?
All right.
No, take that. Count 1 and 2 at $2,500. Count 3 $1,000. Count 4 I'm going to reduce to $1,000.
All right. Thank you, Judge.
Thank you. Have a nice day.
All right, Michael, call me when you bond out, okay?
Yes, sir.
All right, thanks.
All right. Thank you. May I see Darius Akubo?
Reset, Judge.
What is it, med reset?
Yes.
Okay, let's reset Akubo to tomorrow morning. Got it.
I look forward to it.
There you go. Oops, sorry, I didn't throw it far enough. Okay, Lavoris Walker.
Here, man.
Hi, good morning, sir. You've got count 1 and 2 are warrants for violating pretrial. They're both no bond. Count 3, a warrant on a misdemeanor. That is $50. Thank you. May I see, I think this is our last one. Samuel Grant.
Yeah, it's a perfection, Judge.
What was the issue?
Didn't mention
testing?
how the, testing.
ID, okay, let me look here. Hey, good morning, Mr. Grant. Let me look here. The driving testing. Bill tested positive, entered into evidence. Okay. I do find probable cause today regarding the possession of cocaine, but let me ask State, does he have a criminal record?
His last prior was paraphernalia in 09. He had an aggravated battery against a pregnant victim that was in 07. Paraphernalia 01. carry and concealed weapon 02, paraphernalia 01.
Remind me, because it's been a while since I've done this. If somebody has a prior violent crime, are they allowed to have non-monetary release? Are they?
Yes, Your Honor. My understanding is when the current offense is a dangerous offense, then technically speaking, they're not supposed to be released to non-monetary pretrial release supervision.
Got it. Okay, how long has your client lived here in South Florida, sir?
Judge, his entire life, he is 61 years old. At this time, from what he advised me, he does odd jobs, landscaping, fixes bicycles, but he has no money in the bank. He owns no property. Judge, he's asking to be released on free trial.
Do you still live at 527 Northwest 8th Avenue in Pompano?
Yes.
I'm going to release you on your own recognizance. Pre-trial release. You need to be there today. All right?
You, man.
Pre-trial release. There you go. Okay. I think that's it for the morning docket. Am I correct? Okay, everyone. Thank you very much, and we will be back. What time does the afternoon docket start? 1 o'clock. Boy, well, they've changed things since I've been here. All right. Well, we'll see everyone back here at 1 p.m. sharp. Thank you very much. We're out from room 4155. What was the other one? We used to be out from where? 235, right? Well, now we have the big number on the wall in the back. We're out from room 4155, and we'll see everyone back at 1 p.m. Thank you.